in these civil proceedings, they're entitled to file what we call an interim or an interlocutory appeal before trial. The interesting thing may be whether that appeal even gets heard before trial, given that we've agreed to this procedure where we're going to have a trial next February. So obviously, if the government succeeds in undoing the injunction, we're back to a situation where all of the people who have been grandfathered will be illegal, theoretically. And if we win, and we've cross-appealed to try and cover some of the holes I talked about earlier, then it'll continue on, at least pending trial. But ultimately, the trial judge is going to hear the evidence, and a lot more evidence than what was before the court on the injunction application, and will have to decide whether or not the MMPR causes some, and we only need one patient to be put in a position where they have to choose between their liberty and their health in violation of their Section 7 charter rights. And that is not subject to a reasonable, that the government can't produce evidence to support a reasonable limit on those rights, that the MMPR are not reasonable limits. Remember, the government is saying that mold, fire, and public safety are the reasons for wanting to do this. And all of those issues are what we call Section 1 issues in a constitutional challenge. The government has the burden of proving that those things are such that people should be prohibited from producing for themselves. And it's pretty obvious, I think, that there's all kinds of things that people do to prevent mold, to deal with electrical and safety, and as I discussed earlier, there's no market for criminals to invade your grow-up because they can't sell the product after anyway.
Just to further complicate John's answer, if I may, there are some 222 other cases brought by self-represented litigants in the federal courts currently pending. Breaking news as of today, all of those plaintiffs that were in the same position as John's plaintiffs that meet the criteria of the Allard order have had their federal court cases stayed, subject to being able to make argument to the court on why they fall outside the Allard criteria. So a number of those will be stayed, but not all of them. The rest will go forward. Stay is a legal term that means essentially suspended or stopped until John's trial is completed. There are also ongoing litigation, mostly by self-represented litigants in most of the provincial superior courts in this country. I'm representing 3 individuals in BC Supreme Court seeking similar relief to the relief granted in Allard, plus some expansion of a couple of the issues that were not adequately dealt with by the trial judge in Allard. And so even if, for example, the Allard decision is overturned on appeal, it may be that I have in BC Supreme Court a separate injunction which could have then some applicability not just to my clients but to other patients in British Columbia and with persuasive effect across the country. So as with all things in medical cannabis since 2000 at least, and quite likely before then, the picture is very gray and very murky, and it's very hard to see what's coming and even what the ramifications of these decisions is going to be. I think it's fair to say, and Justice Phelan of the federal court recognized in his decision issued today, staying a number of these cases, this is a pretty unique scenario when hundreds of people have gone to the courts claiming substantially similar relief in terms of their rights under the Charter.
My name is Neil Magnuson. I'm an activist that's been fighting for the legalization and regulation of this plant for a long time. I do have a question I'd like to preface it with a comment. Thank you, whoever's putting this on, Mr. Allard there. Thank you so much. This is awesome to see. We've come a long way in the last 10 years. My question would be, this is on the schedule as a debate, and I was wondering if you actually tried to find anybody that could debate any of the aspects of legalization or in favor of prohibition in this debate.
I'll just throw one thing in there. I did add and related cannabis misconceptions. I knew there wouldn't be much of a debate. Has anyone got any other questions?
You could have got Chuck this in. Yeah, I just wanted to say thanks to everyone for putting on this. This is great.
being a former alcoholic and a cocaine addict myself, just to answer the lady's question, a lot of kids in the 70s and 80s were put on Ritalin, and this is a fact. 9 out of 10 of them became dependent upon cocaine and heroin later in life. So my question to the panel is, what's going on about the prescription drugs they're giving our children, like without, you know, all the stuff for antidepressants, when we know that they actually cause drug addiction, hard drug addiction, or alcoholism later in life, these children. So I just want to know what's being done about that.
Well, I was involved as counsel for the Vancouver Area Network of Drug Users in the supervised injection site case and learned something about what you call hard drugs. And sure, you know, the prescription model has its defects because doctors are the gatekeepers, and maybe there needs to be some refinement or amendment there in order to prevent the abuse you're talking about. But don't make the same mistake when you talk about heroin and other hard drugs that people used to and still do in relation to cannabis. When a person who becomes addicted, and usually addicted because their doctor has been prescribing opiates to them, and then because they want more and more, because that's the nature of an opiate addiction, and they get cut off, they go to the street. And when they go to the street, like the famous actors, they get bad stuff and they die. Or they go into the alley to shoot up, and to shoot up quickly, because the cop is there wanting to not bust them anymore, take their rigs, smash their rigs, take their drugs that they've worked hard to get. And so they shoot up quickly, and they miss their veins, and they get abscesses, and they don't go and get health care, because they've been driven underground. And it's the stigma and the driving underground that then leads to them going off and having sex with other people and spreading infectious disease, and you end up with a public health crisis in the downtown east side. You know? And you have governments wanting to try and do something about that, while your federal government tries to prevent them from doing something about that. So remember, drug addiction is a health issue. It's not a criminal law issue. We should get out of the business of using the criminal law for health care issues so we can get on with trying to assist people.
Testing. Yeah. But with these new laws, an aspect which isn't usually discussed, but which I read, is that the licensed producers, the patient has to obtain them through a secure courier, not purchased from a dispensary. How is that aspect working out? I mean, is there a coast-to-coast cannabis courier company, and how much does that add to the cost of the product?
It has to be a secure method of delivery. It doesn't necessarily have to be a secure courier company, right? So I think that using any of the commercial shipping companies is probably sufficient for MMPR purposes. But in my remarks earlier, and I'll just sort of underscore what I said then, it's not the way we distribute medicine to people in any other aspect of life, and it's not the way we should be distributing medicine to people when that medicine has a component where the patient really likes to be able to see, smell, understand, and talk to somebody who understands the medicine before purchasing it. I think that there's room in the marketplace for both methods of delivery, but I certainly urge people, and I urge LPs in particular, and the government and patients in particular, to continue to stay after the Government of Canada to open up supply chain options for patients, because at the end of the day, the more choices we can give to people and the more freedom we give them to exercise those choices, the better for everybody.
But remember, it's the provinces that have to get involved here in order to regulate dispensaries and so on. That's part of their constitutional jurisdiction. It's not part of the federal government's jurisdiction. So that's, I think Joy Davies was talking about this and had her booth outside. We need to get the provinces to start talking about what they're going to do when it becomes legal, how they're going to do the retail part, just like booze and tobacco and so on. The feds are going to be involved to some extent, but it's going to be basically up to the provinces. Just like with the healthcare insurance stuff, the provinces aren't stepping up to the plate in order to deal with the realities of what's going on.
I think one of the big issues here is Health Canada has a very, very, very heavy footprint over the whole industry right now, and Health Canada doesn't really care about this stuff. It's a bureaucracy trying to get through a whole new industry that it's been landed on its head and it never asked for. And so dispensaries is just another aspect of this that they don't want to have to deal with. So if they make you sell it online, and they make you all go online to order it, then their thinking is we're going to keep it out of churches and neighborhoods and schools. But it's really what it comes down to is it's just easier for them. And when it comes to a point where the whole courier system is suddenly a weak network, then, you know, maybe they'll see it as something they need to work on. But right now, you know, they're too busy hiring people to try and get through 600 applications for growers. They really don't care about dispensaries.
Just wanted to some clarification. Can personal production license holders right now grow their own medicine, or are they doing something illegal at the moment?
Depends on whether or not your license was valid on September 30th, 2013.
And whether or not your authorization to possess was valid on March 21, 2014.
Well, okay, if we're going to get technical.
Now we're debating. Now it's debating. You got the quarters going.
This guy used to work for me. He's trying to steal all my business.
I learned from a master.
What I've been telling people is that, you know, I mentioned the Narcotic Control Act. The Narcotic Control Regulation 53 is the regulation that authorizes practitioners, which includes veterinarians, to administer, prescribe, sell any narcotic to a patient that they're treating for a medical condition. And that is dealt with in the reasons for judgment in our case. It's existed going way, way back and continues to exist. And so while the doctors have been a problem in this whole program, if you've got an MMAR or did have an MMAR authorization to possess, presumably you can go back to the doctor that gave you that and say, hey doc, write me out a little chick that authorizes me under Regulation 53 until this court case gets decided, so that your possession becomes lawful that way without having to go to Health Canada and go through all the hoops.
The short answer to your question is, generally speaking, yes. If you were previously licensed under the MMAR, you can continue to produce for your own personal use.
So licensed producers work under a fairly strict regulatory regime. They've got to make sure the product they provide meets minimum standards, no bugs, no pesticides, no heavy metals, and they've got to measure and advertise potency. In this town, at least, we have dozens of dispensaries. To the best of my knowledge, they have no such standards. I'm wondering if the panel believes there ought to be such standards for the dispensaries. And if so, what would be the mechanism for getting that in place? Is it community and social pressure? Is it some kind of regulatory initiative?
Well, caveat here, I represent a number of dispensaries in and outside of Vancouver. But I'll say this. You probably don't need the level of quality control and restrictions that are built into the MMPR for cannabis, because it is, generally speaking, a safe substance, even when grown under some of the worst conditions. That said, in my view, if you're delivering product to people with compromised immune systems or critically chronically ill people, some minimum level of standards and quality control ought to be in place. I can tell you this, though. Just because dispensaries aren't currently regulated from the outside doesn't mean they're not employing internally standards for the quality control of the medicine. There are, at least amongst my clients, certainly more people coming to the dispensary trying to sell their medicine to the dispensary than the dispensary is willing to take. It's not just like they're grabbing low quality street-level bud and then selling it as medicine. Most dispensaries employ fairly rigorous quality control standards internally already. And if you want to broaden that out, then what you need is the participation of government to do that. And thus far, Health Canada has been absolutely unwilling to bring dispensaries into the fold, despite being told by the courts in multiple cases, you've got this currently unlicensed network of distributors. regulate them and bring them into the fold, and then you can help ensure supply and quality supply for everybody. So it's a failure of the regulator, but let's be clear, dispensaries operate under their own set of quality control standards, some of them better than others, but some of them, in fact, quite rigorous.
Go ahead.
Yeah, I just wanted to comment on the present licensing. How many folks in Canada actually have licensing to grow for themselves?
The
Or,
MMR,
yeah, the current program.
the last figure I heard was about 27,000.
You got 27,000 people growing. You know, what a great cottage industry. Why not let them grow a certain amount, and whatever they don't use, sell it off to a licensed producer, and therefore take those people who are maybe on the poverty line and actually start paying taxes and get off the welfare system and create a cottage industry.
Far too logical and
Yeah.
rational.
Oh, that makes a lot of sense. You don't work for government.
Well, I want to comment on your gateway drug thing. You know, it's kind of the opposite for me. You know, I remember I smoked a big joint when I was about 15. It scared the hell out of me the way I felt. And I never ever did any drugs for my entire life. So, I mean, I don't buy the gateway thing either, so anyways, for what it's worth. It might actually be good for them to smoke a little bit to make sure.
Hi. I guess most of the questions are going to the two legal bookends here, but gentlemen, thank you. I want to ask you both a question about derivatives. I know patients want derivatives. I know doctors want derivatives, and I also know licensed producers want them. It's one of their top two priorities is affordability of derivatives. When do you think the next bit of work's going to come your way where somebody's going to challenge it? Because I can't see a licensed producer trying to go that way, because they'll have their license rescinded, and I'm hoping it'll be a dispensary that will mainstream on derivatives. But when do you think you're going to get your next bit of work coming your way, and how?
Well, I'm currently waiting on a decision from the BC Court of Appeal on the issue of derivatives in a case called R.B. Smith. We were successful at trial in convincing a judge in the BC Supreme Court that the restriction to dried marijuana alone in the MMAR was arbitrary in violation of Section 7 of the Charter, of the patient's rights guaranteed by Section 7 of the Charter. I had expected a decision by now, and if I get one, presumably while the decision itself will apply to the MMAR, the reasoning behind the decision ought to apply with equal vigor to the MMPR, if not greater vigor, because one of the things that the government went after us hard at trial is, well, you have no quality control, you have no standardization, you have no regulatory environment to create these derivative products. The judge's reaction was sort of along the lines of what I said. Well, Judge, that's because we've asked for it and they've refused to do it, and in fact they've exempted cannabis and cannabis-based medicines from the regulatory scheme that makes the most sense for them to be in, the natural health product regulations under the CDSA. So that'll give some guidance. I will take issue with something you said there. I think that, you know, companies that get adverse decisions from the Government of Canada in their regulated industries sue the Government of Canada for judicial review. It happens in the pharmaceutical sector quite a bit. If you look at the federal court trial decision, the BC Court or federal court of appeal decisions, there's a lot of cases where pharmaceutical companies don't like the answer the government's given them, and so they go to court, and you have a judicial review process. That's what it's for. And oftentimes, the government is reviewed by the courts, and then the company gets to market its products. So I don't think an LP would have its license revoked if it went. If it sold derivative products unlawfully, sure, you're breaking the law. But if it wrote to the Government of Canada and it said, you know, I've got a tremendous amount of patients that want these products, here's what I can produce, why can't I do it? And they're told no, well, you're entitled to take judicial review of that decision, and you're entitled to litigate that issue in the courts. And I encourage anyone that wants to take that on to hire one of the fine lawyers up on this panel. Start with John. Call him Chris. You won't like his pricing. And then you can call me.
I was going to say, any LPs who want to donate anonymously to the cause, we can arrange for that. The situation, as I think I mentioned in in the Allard case, we are challenging that limitation as well. So it's before the federal court, and if we succeed, it will be countrywide. And the injunction, because of the way it's worded, I'm of the opinion that it protects the people in BC currently who are doing extracts. I mean, extracts, there's just no doubt that ultimately that's where this all will have to go. And the interesting thing was, and I don't know what other evidence was in Smith, Kirk, but in Allard, when cross-examining them in relation to the injunction, they put forward Corporal Holmquist on the fire, mold, and public safety. And the only thing they dealt with in terms of extracts was the oil that's made in a very dangerous way by butane extraction. And so, the only thing they could come up with, it seemed, as a concern about extracts, was those that are made in a dangerous way, which is obviously something that needs to be regulated in terms of safety and so on if somebody's going to produce it. But as I understand it, 90% of the extracts aren't made in any dangerous way, and there's no reason whatsoever to limit them, and so hopefully we'll succeed in opening that up. But I definitely think it's in the interests of the LPs to push that, and maybe if they push that as a group, I think it would be pretty outrageous for Health Canada to pull their license simply because they are saying, look, extracts instead of smoking, Most of the doctors say smoking isn't good for you. So sure, we have other products that aren't smoking from dried marijuana, but the most common is still smoking. And so why is Health Canada supporting a method of ingestion which can be harmful to your health when there are other methods that are not?
We're going to take the three people standing up here, and I'd like to ask our American friends what they thought about this conference in Canada after that, if that's all right. Go ahead. Actually, this gentleman's been standing there for the longest time, sorry.
Actually, I have two questions. One for 420. What kind of PE ratios are you looking for in companies?
What's E?
E? Earnings, if there are any. But what kind of projected earnings are you looking for profit on companies that you're looking at the present time?
So, there aren't very many earnings right now.
No, but I'm just saying,
yeah, over time, we were talking about this today. A company was kind of sharing their expectations. It's a high-growth industry. You expect 30, 50, 70, 100.
That's quite high for a profit on
because it's early. But right now, there's literally, the best company in the sector is by GW Pharma, UK company. They're investing, they're losing money. A few companies have revenues over $5 million per year, but they don't show net income. Some of them, there's like 3 of those, and they don't even show positive EBITDA right now. So it's a little early. That's one of the frustrating things right now. In the private sector, there's some companies, you can't say what PE they trade at because they don't really trade. It's a fair question. I think if you saw my presentation earlier today, we started off with a concept a few years ago. We're now kind of proof of concept, Wild West though. And,
I understood it, but I was trying to wrap my head around 50-60% profit over earnings. That's kind of unheard of in today's markets, right? More or less.
There's money in Facebook. You would think that, I don't know if Tweet, for instance, will be that one, but we'll see what their numbers look like. But you would think, based on the perceptions, that these are companies that can grow a lot in the next 5 years. Regulatory, look at Canada. We're talking about this. We have no idea what's going on. Canada, you're going to ask, I don't want to jump the question, but Health Canada, it's unbelievable to me as an outsider. I guess I'm immune if there's anybody in here from Health Canada, but no extracts. This is crazy.
No, I agree.
And so they're going to fix the system, and we don't know what the elections will be here with Trudeau and how that might play out. But the hyper-growth is what's going to likely lie ahead.
Okay, my next question more or less is a debate for John for growing your own at home.
Yeah.
Okay, well, as an investor, the way I look at it is, if you were to grow your own at home, and let's say we take 24 million Canadians who grow their own at home, the bottom line for my investment into any one of these companies means that you're going to take away the bottom line from what I'm looking for as a take-home profit from these companies for my investment on the long term. Two, coming from my PI Paul neighbor, is that he doesn't want any homegrown operations in his neighborhood, whether it be 1 plant, 10 plants, or 100 plants. And the debate here is by having a homegrown system, he's worried that fires can, it will be, or could happen, regardless of the best electrical contractor you have in there.
I'd like to get into the first part of this question. As you talk about, say there's like 33 million Canadians, and we only have, what, 27,000 growers? So really the harm, a lot of patients don't know how to grow their own cannabis. Myself, I spent years, I researched for myself, started growing my own for my own conditions and stuff. But I would say that 90% of the people out there have no idea how to grow standardized medicine. And once they try it, they realize they can't do what they're doing. So these licensed producers that would be able to offer quality control licensed medicine is going to be a great thing. But at the same time, taking away my right to grow isn't going to hurt your body at all. If anything, it's going to benefit for you because a lot of people don't know how to grow. And at the same time, when you talk about growing in some like yard, like 1 plant or 5 plants, I grow tomatoes in my backyard. I can grow as many as I want, right? So I'm strict by licenses. And what I'm looking at right now is there is a law, Bill S-10, if I'm right, but it's mandatory sentencing for 6 months or more, and that's being passed. So when I look at law right now is I can grow 5 plants in a grow tent. So that's already being passed. If you take a look at that law, all the licensed producers here will really realize it, that really, I'm going to grow 5 plants at home. If they do wind up taking my license away and we don't win that appeal, I will always grow my medicine. And at such time I cannot grow my medicine, I'll be grateful that I'll be able to buy from a licensed producer when I'm old enough or I can't grow anymore. So there's lots of different benefits with myself being able to grow, helping patients. It supplies a huge network of hydroponic stores, nutrient companies, educational people going around educating these people. It's a whole other network that you're really not looking at. And at the same time, it's still benefiting your network because of well, the industry is now, it's cannabis, right? So we're seeing so many different aspects of what's happening. But I do believe that we can work in harmony 100% together, and that's what the system should look at, about legalization.
Okay, but
and that is going to happen.
No, I'm with the legalization and everything, but I'm also debating with you as if my neighbors or people in the neighborhood, well, for instance, and as an investor that, not just you, but let's say somebody else says, okay, I have 3 people in my house, I'm allowed 15 plants, or I've got 6 people in my house, I'm allowed 30 plants, because under the law you're allowed 5 plants per person, correct? Not
well, I'm just saying, I'm not saying it's legal or not.
No,
I'm just looking at the law, and you know what, you're going to get into different aspects of that. If you're going to run 30 lights in your garage, and you got a building charge, your building going to kick in your door. If I got 1 light in my garage, but they grow 10, 5 plants, they're going to know who the hell I am, I'm going to kick in and grow my medicine. So you got to take a look at different parts of that. So if you want to go on a big aspect, you want to do it for money, well then that's going to basically kick you in the ass. If you want to sit at home and grow your medicine and be under the radar and do what I'm doing and stuff like that, it's really truly looking at cannabinoid programs for my condition. I don't think any cop's going to kick in my door because I have a grow tent in my basement with 5 plants.
Okay, but what about the security? For instance, if I got
5 plants,
yeah,
but
if I have kids next door to your little grow-off, and you don't have the filtration in place and it's stinking up my neighborhood, what are you going to do about my neighbors?
I have people who call me about that. Neighbors, they think I'm assisting all kinds of bad things because their neighborhood's being stunk out by the growers. And I am sympathetic to them. I think that it's outrageous that we have people who are authorized to grow marijuana that aren't taking steps to make sure that they don't interfere with their neighbors' peaceful and quiet enjoyment of their property. It's simply outrageous. The great majority of people who grow marijuana don't do that. If you've got 27,000 people and they tell me about half of those are in BC, the number of complaints in terms of smell across the country are still relatively small relative to the number of people growing. When I cross-examined Health Canada on the number of complaints they had about smell, I said, well, why didn't you call them up and tell them, to get the proper procedures, the proper equipment, and to change their filters and make sure that they don't stink people out, just like some people are able to do in an apartment with a common wall with people next door. And Health Canada said it's not our jurisdiction to control smell. So that was their response. The evidence in the case, they called an economist, Dr. Grudendorst. He said that sure, the market will develop quicker if you don't have personal producers, but it will develop slower and still will develop over time. The existence of personal producers is not going to stop this market from maturing. Okay? That was the evidence from the government. The evidence also to do with fire, most fires are in kitchens. If you look at the statistics of fires across the country, there are people of my age leaving different kinds of pot on the stove that bubble over and cause fires. They're not going to take kitchens out of houses because they're the most common fire. You talk to a certified electrician and he'll tell you that there is no greater danger from a marijuana grow-up as long as it's properly inspected and properly put together by a certified electrician. And we also know you've got these bloom boxes and all these other things that take care not only of fire and electrical safety, but also in terms of the humidity and the mold issues and all of that. The people who are complaining about these things are neighbors who have grown up with this in the past market, where, you know, the illegal operations hastily thrown together to quickly crank stuff out the door to try and make $1, cutting all kinds of corners. They've caused the problems. Medical people have security systems. They call the police if somebody tries to break in. And they don't have a market, as I said before, anymore for these grow rips and so on to happen in your community. So you have to get current with the evidence and not rely on old stories to say we shouldn't be allowed to personally grow.
Yeah. If I may, the same problems that you come up against with a neighbor growing wheat, you come up against with a neighbor growing chickens. You know, you can set up a lathe in your basement and you're at the risk of starting a fire. There's no regulations about that. So it just comes with common sense, really. Go ahead. Yell it out.
Under the same rights as you grow cannabis. I have 3 questions actually, fairly quickly. What is was the tweet representative? I think it's the third guy from the end now. Okay, well, one of the things I wanted to know about was the Canadian Food Inspection Agency standards. They were pulled from the MMAR licenses, which essentially allows MMAR producers to be exempt from those standards. And it's the same as a compassion club or a dispensary, because if it's a society, they're not subject to CFIA standards. And when I was looking at the MMPR, apparently they're also exempt from the CFIA standards, although I also heard that they should have CFIA inspectors in. And I'm just wondering if that's being done under the new MMPR, because there was some mention about some of the cannabis going. So maybe the WorkSafe guy can answer that. I'm not sure. And the other thing I've heard too is that Canadian Food Inspection Agency has let go of some of these inspections. So I'm kind of wondering what the licensed producers are doing, you know, if there's some sort of regulatory function in that. I understand that cannabis itself has to be inspected, but for instance, Health Canada's Lot 4 had arsenic in it that were above the accepted level. And Parry Systems was also granted an exemption from the Canadian Food Inspection Agency. So
I'm unaware of any requirement in either the MMAR or MMPR that requires Canadian Food Inspection Standards to be applicable. There was an exemption called the Marijuana Food and Drug Act exemption.
That's right, December 12, 2000.
That was promulgated by Parliament in the wake of the Hidsig decision. And that was brought into play in order to allow PPS to sell its medical marijuana to Canadian authorized patients, and also to allow designated producers to sell their produced medicine to their patients for whom that they're providing care. Because otherwise the Food and Drug Act would have prohibited the sale of the product.
Exactly.
And so that's why it's changed.
My understanding is the MMPR, the producers under the MMPR, are going to be have to meet the CFIA standards, and that would make sense that MMPR growers would have to meet the, the CFIA standards, that if you grew your own 5 plants or whatever, and you don't have to, you don't have to have an inspection when you make cookies, for your, brownies or Girl Guides or something. You don't have to have an inspection requirement. So I'm just kind of wondering if there's anything with WorkSafe BC, if they're looking into this at all, if they have inspectors go on to the licensed producer premises, or what's going on with that aspect of this?
I have to say we're about 7:05 over. I don't want to lose the crowd because we're going to have a party with a purpose. So if you don't mind, maybe just grab a couple of these. Ladies, can you do it real quick behind?
Okay, yes.
Just talk to me personally. They're going to be here for a little bit.
Okay, yes, thank you.
Yeah, sorry. Next. I don't know what the answer is. We don't really know the answer to that one.
Just something, an opinion as a viewer, I just want to give. We all humans here participate in the development and so forth of things. What I'm trying to say is, if the legalization of marijuana goes on and is positive, it's due to the mobilization and the demand of the population. So please, we have to take the Liberal Party out of it, because what I want to tell is, you come as a human race, trying to help the human race, without the label of liberal, because it comes across to me that the liberal did this for the population, so now I want you to vote for me. So that's one. The second is, people have to learn to have a good diet, so they don't get sick. And the third is, if you read Edgar Casey, he is very knowledgeable of castor oil, and also that is very good for your health, just equivalent as marijuana. And the fourth thing I wanted to say, it was the gentleman that said that he had used cocaine. Well, he has never done cocaine, because cocaine is super expensive. What people talk about cocaine in the street is only 20%, the rest is kerosene, bleach, ammonia, nail polish remover, etc., etc. So it's about time that people educate themselves about what real cocaine means, and cocaine is not a narco. So you better have all your knowledge before you go about cocaine. Thank you so much.
All right. The town hall meeting. What would you like to say?
I just think there's a bit of confusion, even though I'm familiar with the contours of the MMAR and MMPR. I think some people who have authorizations to possess think that they can grow right now, and I think there's a confusion with that.
Well, if you're saying there's confusion amongst people that have authorizations to possess under the old MMAR about whether or not they can produce, if you had a personal use production license that was valid on or after September 30, 2013, and you have a corresponding authorization to possess valid on March 21, 2014, then you are entitled to both possess cannabis and to produce it according to the terms of your old licenses. You no longer have a license, you now have a constitutional exemption. Similarly, if you were a designated producer under the MMAR with a valid license as of September 30, 2013, and your patient's MMAR authorization to possess was valid on March 21, 2014, you're entitled to continue producing as a designated producer under the old regulatory scheme. If you never had a production license, well then your ATP never gave you the right to produce, and you still don't have the right to produce.
Exactly. A lot of people with the ATP think that they can produce right now, and that's just confusing, and I just want people to know that they can't.
That's right. That's right. Thank you very much. We're just 10 minutes over. We could go on all night, but I think everybody's getting a little tired. I'd like to thank everyone for coming out today. I think it was a very interesting day. Certainly like to thank your Canadian and American friends. I wish I had a little more time. You're going to ask you what you thought and how you compared. We'll have to do that later.
Oh, yes.
I'd like to thank our platinum sponsor, BC Chronic. A party with a purpose is coming up. Where's Michael? When does the music start? 2 minutes. 2 minutes. Set it up right now. Okay. 5 minutes. Okay. So we'd also like to thank Canon Cannabis They're one of the sponsors tonight. Our company, NextGen. Coffee break sponsor was THC.V. Our Palladium sponsor was our